U.S. immigration. We provide clear immigration news and insights and connect you with experienced attorneys who can answer your questions and guide you through the process. From visas to green cards, asylum to citizenship, we help you find the right legal expertise so you can move forward with confidence. ImmigrationQuestion.com. Real news, real answers, real quick. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by ImmigrationQuestion.com, your trusted source for immigration news, expert legal insights, and real-time conversations with licensed immigration attorneys. My name is Max Castro, and I'll be your host for today's important session, Understanding the Employer and the Employee's Responsibility in Completing Form I-9. Every U.S. employer is required to verify the work eligibility of their employees, and Form I-9 sits at the heart of that process. While the form may appear straightforward, even small mistakes can carry significant consequences, ranging from costly fines for businesses to immigration risks for workers. That's why today's session is designed to bring clarity, highlight best practices, and share strategies to help both employers and employees to protect themselves. We are honored to be joined today by attorney John Lawit, a seasoned immigration attorney with over 40 years of experience. Based in Texas and New Mexico, attorney John Lawit has represented individuals, families, and businesses across all areas of immigration law, including family and employment-based immigration, humanitarian relief, asylum, and business compliance. His deep knowledge and decades of experience make him uniquely equipped to guide us through the complexities of I-9 compliance. Attorney John Lawit, it is a pleasure having you with us today. Welcome.
Thank you for inviting me, Max.
Of course. Before we dive in, a quick but essential reminder, ImmigrationQuestion.com is a two-in-one platform that connects users with licensed immigration attorneys. We're not a law firm and we are not affiliated with AILA or USCIS. All legal services are provided independently by attorneys in our network. Let's jump right in. Attorney Lawit, can you start by explaining the purpose of the Form I-9 and why it's such a critical part of the employment process in the U.S.?
Yes, the purpose of the I-9 is to make it very expensive for employers to hire people without proper documentation. The idea being that if the employer has enough of a financial deterrent, they will not hire somebody who is undocumented. And the idea was USCIS, before it was USCIS, it was the INS, part of their responsibility was to find people who were working illegally. But when we changed to the more modern form of USCIS after 1990, they came up with this idea that there would be a form that would be filled out by both the employer and the worker at the time of hire, and that form would have requirements of strict documentation requirements. And if those documentation requirements are not met, the worker would be considered to be undocumented, and the employer could be fined thousands of dollars. Now that's how it began, and it was very passive and was not aggressively pursued. They did begin aggressively pursuing it, and there was many high profile raids of factories, much like you saw with the Hyundai factory. And that was going on a fairly regular basis. So the purpose of the form was to punish employers, because Congress was convinced that it's employers who are inviting these undocumented workers into the United States, and that if they could just take the incentive away from the employer, then the undocumented worker wouldn't be able to work and would not come to the United States. That's the theory. That's why they started it. It's been pretty much of a failure in many ways. In particular, it's a failure in the sense that it's really turned into a tax on employers. Most employers who are aware of I-9s and decide to run the risk anyway are willing to run the risk because they believe that the financial consequences will be something they could bear. But in any event, it is very important, not because it's significant with immigration law, but because of the large amounts of money that can be. I mean, I've had my own clients, 25, 50, 100 people arrested at a time. They used to do it much more than they're doing it now. But the I-9 form was felt, since they couldn't hire their way out of the enforcement responsibility, they would force the employer to be a policeman and do the job that Congress had said the INS was supposed to do. And that's how we got started with this. And at first they weren't making a lot of money on it, but then they realized how to open that cash register and fine employers millions and millions of dollars. And in some cases, they don't even arrest or deport anybody because the worker's already gone, but the employer's got a drawer full of I-9s that were not prepared properly. And so when you talk about I-9s, it's about employer sanctions. The employer is the one who gets penalized for the I-9 violations. Of course, the worker gets fired if an I-9 violation is detected. So let's talk about responsibilities. Who does what? All right, the Form I-9 is the employer's responsibility to complete and maintain. They have to maintain it up to 3 years after the worker is no longer with the employer. So the employer has to attest. In the materials, you'll see there's a Form I-9. There's a place for the employer to attest to the fact that they examined the documents that were presented to them, and the employer has determined that the person is eligible to work. There's 3 types of documents. One is like what you might call the super documents that prove identity, citizenship, and ability to work, like a U.S. passport is one of those documents. A green card is one of those documents as well. But once you get away from green cards and citizenship, things get very, very much more complicated, because there's dozens of work situations that are accommodated through the immigration laws that employers must be aware of to know whether or not the person they want to hire is eligible to work in the U.S. I don't know of any employers who prefer to hire people who are undocumented. I know of employers who look the other way, and I know of workers who present documents that comply with the I-9 rules, but they're not allowed to work anyway. And so that is one of the biggest problems that we have. So the worker's responsibility is to produce documents according to the list that is given out by USCIS whenever they start a new job or whenever they have a significant change in their immigration status. They have to amend the I-9. And so once the employee provides the documents and says, yes, I'm eligible to work and these documents are real, that's the last contact they have with the I-9 until their immigration status changes. But the employer's responsibility is ongoing. And so the employer will remain liable for a very long time if they don't maintain the records. And if they do have records, if they're done incorrectly, the employer can be fined. I mean, not only will they fine the employer, they'll put the employer out of business. I had one case where I was representing a painting company, and the painting company had a contract to do some painting on an Air Force base. And they came to the gate at the Air Force base to report for work, to report for work, and go to the painting project. And you don't go on a military base unless you're illegally in the United States. Well, they didn't pay any attention to that. They arrested 35 out of 40 workers. The employer had to breach his contract and went bankrupt because he lost 85% of his workforce in one day. So it's serious stuff. Not only from the point of view of the employer who can be put out of business because of the fines involved, but for the worker, because if there's glitches in the I-9 system that workers exploit all the time. If you don't have one of those super documents in the first group, then you have to present a combination of other documents. It could be a work permit and a social security card. It could be a driver's license and a social security card. And the employer must attest that they're legally eligible to work. And then here's the documents. the employer has to attest to the fact I have reviewed the documents. And to the best of my knowledge, this man is eligible to work in the US. They both signed the document. And so they're both bound under penalty of perjury for what they say. So that's the responsibility part. Who does what? Many employers make very common mistakes, and some of them are almost silly. A lot of employers don't even know what an I-9 is. They've never filled one out. They have no idea what it's for. USCIS engages in no community education whatsoever. They're supposed to figure this out on their own, and if they don't, armed officers show up at the place of employment. Now, what you're looking at, this is the information sheet given out by USCIS that tries to tell employers about how to fill out the form, what questions they can ask, the purpose of the form. And so, but for most employers, it's really not safe to contact the government, because if they can figure out that the people you have hired may not be documented or may not be able to work in your business, you're likely to get a visit. And this is very serious stuff these days. And so you don't want them showing up at the place of employment. We might want to spend a minute on that.
For sure.
Many employers.
Sorry, go ahead.
I
just had a quick question. Say an employer discovers an error on an I-9 after it's already been submitted. What's the proper way to correct it without making situations worse?
Well, there is a book, and I recommend that if you're going to work in the United States, or if you're going to employ people in the United States, that you get this book. The book is free. You can get it on the USCIS website at uscis.gov, and they have a portion of the webpage called I-9 Central. At I-9 Central is everything having to do with how to properly fill out the I-9, and they always have a section about correcting errors. As long as the error is caught in a reasonable period of time and is corrected and initialed, and the employer collects the new document that might have been the source of the error, it's fine. They understand that people make mistakes on the form. Since they provide absolutely no education and the employers have to figure it out by themselves, they get a lot of stuff that they really don't want to get. But that's the way they set up the system. And so it's set up to fail, and it has. I mean, well, if you take the president's word for it, it's a total failure because there's more undocumented people working than ever before. So by his own words, the president has said this program is a complete failure. Where's all the employers refusing to hire the aliens? Now, there is a thing for the employer in here that's very, very important. It's called a safe harbor. If the employer does his or her job and reviews documents that appear facially legitimate, that is, they don't look like forgeries, and the worker presents those documents to prove they can work, the employer is protected from being fined because it was the worker who presented the phony documents, and the employer had nothing to do with it and had no idea that the documents were not real. And that's another level of problems that come up with this. So assuming the employer knows about the I-9s, they have no idea about why it's important. They have no idea about the amount of fines. They have no idea that the government won't hesitate to put them out of business just for hiring people who presented facially legitimate documents. It used to be, back in the day, there was a thing called a party pack. And a party pack was a group of documents that undocumented people could purchase that would contain a social security card, a driver's license, and a green card. All of them fake. The only thing that was related to the person carrying them was the picture and the name. And if those documents, you could fill out any I-9, and no employer would be subject to a fine because the documents looked legitimate. As long as the documents look legitimate, the employer is protected. That's the safe harbor. As long as the employer looks at the correct documents, and I recommend all employers make photocopies of all documents that are presented to you, because if the issue comes down to what the document looked like that was presented and you don't have a copy, the worker is going to do what the government wants, because the government's going to tell the worker they're going to be able to stay, and then the employer is really going to get fined. So this has become very, very expensive. The other mistake is the employers don't know about the M274. The M274 is updated every 6 months. It is the Bible. If the employer does something that's okay in the M274, USCIS cannot fine them. If the worker presents documents as stated in the M274 that's current for that period of time, the worker can't be charged with submitting fake documents. So it's a protection in both ways. Now, the final thing is the best practices. First thing is the employer should tell the worker that they are going to hire that they're going to have to present documentation to be able to fill out an I-9. The employer is not allowed to participate in the selection of the documents that the alien wishes to present, but the employer can certainly give them operative pages from the M274, which tells them that information. So both the employer and the worker benefit by using the M274 book that's published by the Department of Homeland Security. And that's the biggest mistake they make. Neither the worker or the employer looks at the M274, and they have no idea it even exists. And of course now, I mean, they send out letters if they detect something is wrong. For example, if the person presents a phony Social Security number, the employer may get a letter from the Social Security Administration. It's called a no-match letter. And they tell the employer, you got 30 days to fix this or fire the person, and we want proof. And so once that starts to happen, then they're into the employer's business. Now, they're not, if ICE shows up at the place of employment and they don't have a warrant, they don't have to be let in. And if they do have a warrant, the warrant must be signed by a judge, not by some administrative agencies. Even if they do have a warrant, it's going to be limited. And the employer has to read the warrant and see what it's limited to. What they really want to do is they want to rummage around in the employer's drawers and see if they're employing undocumented workers. That's really what's going on here. And of course, they're scaring the employer the whole time, telling them they're going to go to jail, they're going to be fined all this money, they're going to go out of business, whatever they can scare them with. And so one thing that a lot of workers do is there's no requirement that the I-9s be kept at the workplace. They have to be presented for inspection when requested within 36 hours, but it does not have to be at the workplace. That's a simple thing employers can do, just remove them from the workplace and keep them off.
Always an honor discussing and interviewing you here at Immigration Question, Attorney Lawit.
Sure.
We're just waiting for you to come back. To everyone tuning in from Facebook, YouTube, LinkedIn, and beyond, thank you for joining us. Whether you're an employer, HR professional, or employee wanting to understand rights, we're grateful to have you here. If this is your first time with us, welcome. ImmigrationQuestion.com is a meeting place between immigration attorneys and individuals with immigration concerns. Our platform is trusted by many AILA attorneys who use it to connect with clients, and with ImmigrationQuestion.com, you can ask your immigration questions for free in any language and get connected with a licensed attorney for legal guidance. In fact, many of our users also qualify for a free confidential consultation. Just visit www.immigrationquestion.com today to know more. That's not all. We've recently been accredited by Better Business Bureau as well, BBB. This means that we've earned recognition for honesty, transparency, and putting clients first. Attorney Lawit, with your decades of experience, what are your thoughts on how ImmigrationQuestion.com is helping both immigrants and attorneys connect meaningfully, and in particular, tackling challenges like the I-9 compliance?
Well, your service is very valuable because you can tailor the presentations to very timely topics because you're dealing with a lot of different attorneys that are doing a lot of different things at the same time. In addition, your platform is unique in the sense that people with the questions get to ask them right then during the presentation and get immediate answers, maybe not complete, but immediate answers to their questions. One of the hardest things about immigration law is finding it. I mean, we can talk about it all day, but where do you go to look for I-9s? Where do you go to find out how to fill out an I-9? Where do you go to find out about the fines that might be levied against an employer? It's not intuitive. You have to know where these things are to put them all together.
Thank you very much for your perspective, Attorney Lawit. It's very encouraging to know that the platform is making a positive impact on both immigrants as well as attorneys. Before we shift into the live Q&A, what are some of the most common pitfalls that you see in the I-9 compliance, and how can businesses and workers best avoid them?
Well, the first pitfall I see all the time is the employer doesn't appreciate the significance of the I-9 process. And so they pass it off to the high school student who's there for the summer, for example. There's no particular requirement to fill out an I-9. You have to be the employer, but be the employer means the actual employer or the employer's employee who's been delegated with this responsibility. So they see it as a clerical, the employer see it as a clerical issue, and so they treat it as a clerical issue without understanding the significance of it. So it's not a clerical issue. And the person who's going to be making these decisions about the documents is making decisions about people's lives. And if let's say the person is eligible to work and the employer won't let them work because they don't think the documents look real enough, and the employer makes a mistake, they're subject to liability to the worker. So the employer proceeds at their peril in doing these applications. So if you're going to delegate it to somebody in your business, train them. If people are trained, mistakes don't get made. Mistakes are made because people aren't trained properly, whether it's the employer self-training or somebody in the business training the workers who are going to examine the documents. The other thing to bear in mind is everyone must fill out an I-9 when they start employment. If I want to employ my son, and I know he's a U.S. person because I witnessed his birth, I still have to fill out the I-9 as if I'd never met him before. So that's another thing. Employers make mistakes. They oh, well, the workers need to do it, but my cousin who's working here and just doing me a favor, he doesn't have to fill one out. Well, that's not true. The cousin, even if the cousin volunteers their time, there is no such thing as a volunteer in immigration law. That person will be considered a worker. So that's one of the biggest mistakes, not keeping up with the 274, and in many cases looking the other way because they think it's going to be too expensive to hire somebody to replace this person. It's much more expensive when they come and take the person away than if you make the change from within the business by finding somebody who's eligible to work.
Thank you very much, Attorney, for the very profound explanation. If you're just joining us, we've been having an insightful conversation with Attorney John Lawit on the topic understanding the employer and the employee's responsibility in completing the Form I-9. We're now moving into our live Q&A segment, and this is your chance to ask your own questions. Drop them in the chat or call us live at 516-705-3483. That's 516-703-3483, and we'll get to as many of the questions as possible. Right, we already have the first question in. So we have here a question: will I find new I-9 every year or only one time?
Well, that depends. When you go to work for an employer, you fill out an initial I-9 at the time you begin, usually within a day or two at the most. That I-9 remains with that employer, and the only change to that I-9 will come about if the worker's immigration status changes. If, let's say, the worker was working as an H-1 temporary worker at first, and then they married a U.S. citizen and immigrated. Well, they were able to fill out the I-9 because they had the H-1 visa and they were permitted to work, no problem. but they no longer have that H-1 visa. Now they have a green card. At the bottom of the I-9, there's a re-verification section where when the person's status changes, the employer can capture that information. And that is the employer's responsibility to capture the new information. Got to communicate with his workers. And if their immigration status changes, you got to come see HR or whoever is doing it. You will fill out a new I-9 every time you change jobs, though. But they're not tied to any particular period of time. You could fill out an I-9 in 1990 when it first started and still be working at the same company, be the same I-9. Unless your immigration status changed, then you'd fill in the recertification box. If they change statuses several times, then there is a process where you document all of the changes as part of the I-9 process. All that's covered in the M274 about how to do that. In fact, everything you're going to ask me today and everything we're discussing is covered in the M274. That's how important it is.
Great. We have a question from Blessing. They're asking, can employer keep my passport after I show my Form I-9?
Well, it's a little mixed up. First of all, no employer is allowed to keep your original documents, period. Secondly, a passport is the possession of a foreign government. It doesn't belong to the person carrying it, and it doesn't belong to the person who is going to employ the person. So they have absolutely no right to keep the passport. But the other part is after I show my Form I-9, there's a mistake here. The employer is the one who offers the I-9. The employee does not fill out. It's not the employee's form. It's the employer's form. The penalties are called employer sanctions, not worker sanctions. So it's the employer whose money's at stake here if they do this wrong. But they absolutely cannot keep the original documents.
Understood. Thank you, attorney. Right. We have another question. How long will my employer keep I-9 form after I stop working?
3 years. And then if the person comes back, because sometimes employees come back, then that'll trigger another 3-year period once the person stops working.
Sounds good. So we have another one from Amina. If I change jobs, do I need a new Form I-9 for the new employer?
Yes. Some questions are easy. Now, if she changes the job within the same company, no. But if she actually changes and goes to a new employer that has a different taxpayer ID, then the answer is yes.
Perfect. The next question is from Farida. Is it possible to fill I-9 if I don't have a social security number?
Yes. There are multiple documents that you can pick and choose from. Social security card is one of them, but there's other documents that you could present that would allow you to work even if you don't have a social security number. For example, you have an EAD, an employment document from USCIS. It doesn't have a social security number at all. You don't need a social security number to get the EAD. You need the social security number to work because the social security number is the vehicle by which the employer withholds taxes and gives them to the government. And then that all comes together every year by April 15th when you pay your taxes. But at the time you fill out the I-9, you do not have to have a social security number.
Great. So they're asking, who will check Form I-9? Employer only or government also?
Well, because of the amount of fines involved, I'd suggest the employer and the employee work together to make sure that the I-9 is filled out properly. They both can work with the M274 together. Now, when the government comes, they have an organization called HSI, Homeland Security Investigations. They're the people who are going to show up at the front door of the business. And that's where the employer has to be ready to close the door on them if they don't have proper paperwork. Because if you let them in, they're allowed to rummage around and do whatever they want. If they have a warrant, you stand back and let them in. A warrant signed by a judge. You got to stand back and let them in. But if they don't, you don't have to let them in at all.
All right. Thank you very much, Attorney Lawit.
Sure.
Go ahead, please. Okay.
Oh, I thought we had another question.
All right. I think that was the last question for today. Thank you very much for sharing your expertise. Your clear guidance and practical strategies are invaluable for anyone navigating the I-9 compliance.
Thank you very much for having me.
Of course. And to our audience, thank you for joining us. We hope today's discussion gave you both clarity and confidence, whether you're an employer seeking compliance or an employee safeguarding your rights. Remember, you can always visit www.immigrationquestion.com to ask your immigration questions for free and connect with a licensed attorney. Many of you may also qualify for a free confidential consultation, so head on over to our website, www.immigrationquestion.com. And if you'd like, you can also revisit today's webinar to share it with a colleague and replay, which is available soon on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us again next week for another timely and vital conversation. Once again, thank you, Attorney Lawit. It is truly an honor to have you here. Until next time, stay informed and stay prepared.
Thank you for having me.